Hello and welcome to the Global Antitrust Institute's lecture series. I'm Judge Douglas Ginsburg, and our topic today is the Noerr-Pennington Doctrine. The entire thrust of the Noerr-Pennington Doctrine is to shield from antitrust liability efforts made by what would otherwise be competing firms jointly to get favorable treatment from the government. So it originates in the Noerr case, Eastern Railroad President's Conference versus Noerr Motor Freight Incorporated. It's a 1961 case in the Supreme Court. This case involved a bunch of trucking companies jointly suing an association of railroads and their so-called Conference of Presidents for conducting a publicity campaign aimed at getting favorable legislative treatment. And the truckers who were sued, who brought the suit, were then countersued by the railroads. So each side was claiming that the other had improperly acted to influence first the governor and then the legislature to enact favorable legislation and had behaved badly in doing so, deceiving the public and the members of the legislature and the government. So to give you a little more detail about this, the facts are pretty interesting, actually. Something that goes on even today, this fight between railroads and truckers, in which the railroads typically claim that the trucking companies are not paying their fair share of highway maintenance, and thereby giving them a cost advantage that they have over railroads, or that they shouldn't have in the railroad's view. So the case began in Pennsylvania Eastern with the complaint filed by the 41 trucking companies and their trade association, the Pennsylvania Motor Truck Association. And they sued 24 Eastern railroads and their presidents and the conference that brought them all together, a trade association, and a public relations firm, Carl Bywar and Associates. And they said that the defendants had conspired to restrain trade in violations of sections 1 and 2. And the gist of the conspiracy was that they had engaged in a publicity campaign against the truckers designed to foster adoption of law enforcement practices and laws that would harm the truckers by strictly enforcing weight limits and increasing the amount they had to pay in taxes for the use of the roads, and also trying to alienate their customers and the public at large and destroy the goodwill of the trucking companies. The trucking companies described the campaign conducted by the railroads as vicious, corrupt, and fraudulent, in part because it used a so-called third-party technique, which is to say, creating the impression that grassroots groups and various organizations were on the side of the railroads. Of course, technique that's used to this day. The railroads admitted that they had engaged in this publicity campaign to influence the passage of state laws relating to the burdens on trucks. And they denied at the same time that their campaign was motivated by a desire either to destroy the trucking business or their goodwill as a competitor to the railroads, or to interfere with the relationship between the truckers and the customers. Instead, they insisted that their campaign was in furtherance of their rights, quote, to inform the public and legislatures of the several states of the truth with regard to the enormous damage done to the roads by the operators of heavy and especially overweight trucks. And so they lobbied for and obtained a passage in Pennsylvania of a so-called Fair Trucking Act, which imposed these burdens. The truckers, in turn, persuaded the governor to veto the law. And that's when the litigation began. The case went to trial. The antitrust case went to trial, and the district court entered a judgment that the railroad's publicity campaign had indeed violated the Sherman Act, while the counter campaign of the truckers had not. And it made this distinction between the two on the ground that the only purpose was to destroy the railroads was to destroy the truckers as competitors, based on deceiving, using this third-party technique, deceiving the public officials. The Supreme Court, through Justice Black, who, by the way, had been a senator, the Supreme Court held that, or said that the Sherman Act does not prohibit two or more persons from associating together in an attempt to persuade the legislature or the executive to take particular action with respect to a law that would produce a restraint or a trade or a monopoly. And I'm going to quote now: although such associations could perhaps, through a process of expansive construction, be brought within the general proscription of combinations in restraint of trade, they bear little resemblance, if any resemblance, to the combinations normally held violative of the Sherman Act. Combinations ordinarily characterized by an express or implied agreement or understanding that the participants will jointly give up their trade freedom or help one another to take away the trade freedom of others through the use of such devices as price-fixing agreements, boycotts, market division agreements, and similar arrangements, close quote. So the court said if they were to find that this activity violated the Sherman Act, it would limit and impair the power of the government to take actions through the legislature and executive that indeed operate to restrain trade, but are public acts. And then to quote again, in a representative democracy such as this, these branches of government act on behalf of the people, and to a very large extent, the whole concept of representation depends upon the ability of the people to make their wishes known to their representatives, close quote. So the opinion expressed an insightful appreciation of the role that lobbyists play in providing information to legislators and executive branch officials. And that people do so out of self-interest and trying to restrain the competition from in any way they can using the law. Well, that comes as part of the game in a representative democracy. So the case did not turn on the First Amendment, which of course specifically provides and protects a right to, quote, petition the government for redress of grievances, close quote, which is what both sides in this dispute were doing. But the court resolved the matter as a construction of the Sherman Act without having to interpret the First Amendment. And in a footnote, it said, quote, because of the view we take of the proper construction of the Sherman Act, we find it unnecessary to consider any of these other defenses, close quote, which included the First Amendment defense that had been raised by the railroads in response to the truckers' complaint. So there we have the Noerr part of the Noerr-Pennington Doctrine. We turn now to the Pennington part of the Noerr-Pennington Doctrine. And the slide in front of you is a very simplified version of what is a very rich factual texture, and I'll give you more detail as we go along. So this case comes out of the 1950 bituminous coal wage agreement. The 1950 wage agreement was really reached by the United Mine Workers Association and the large operators to the detriment of the small mine operators that were in the same bargaining unit. But the agreement was, as you see on the screen, that the small unmechanized coal mines challenged this because this agreement provided that the large mines would be allowed to mechanize and thereby shed a lot of union jobs. And had a lot of other features, which I'll get into in a moment, involving influencing public officials. So to give you a better texture of what was going on, the basic deal between the large operators and the small ones would be to the detriment of the small operators who would drop out, or most of them would fail actually, is that the large operators would mechanize and they would pay a much higher union wage and they would fund a health and welfare benefit plan to be administered by the union for the benefit of the miners. And of course, since many miners were going to be retiring, losing their jobs and having to retire, this fund required substantial funding by the employers. They also agreed that they would influence public officials, and that's what gives rise to the Pennington part of the Noerr-Pennington Doctrine. So the obligation to contribute to the new health and welfare fund was imposed on all of the operators, large and small, knowing full well that the small operators, for the most part, would not be able, as a financial matter, to pay the higher wages. They were too small to mechanize, and without mechanization and the ability to eliminate a lot of miners' jobs, would just basically be forced out of business. The benefit to the union, of course, was that the greater productivity was the royalty payments into the welfare fund. The large companies also agreed to do things like not leasing any coal lands to non-union operators and not to sell coal to them or buy coal from them. So the small operators, a small group of the small operators, refused to pay the royalty into the benefit fund and were sued for $55,000 of back royalties that they should have paid based on the amount, the tonnage of coal that they had mined. So the union brought the suit against them to collect the royalties. Now, the court begins with this, not the very beginning of the opinion, but in essence, quote, nothing could be clearer from the court's opinion in Noerr that the anti-competitive purpose did not illegalize, as the court's word, the conduct involved. Noerr shields from the Sherman Act a concerted effort to influence public officials regardless of intent or purpose. And that was indeed quite clear in the Noerr opinion. Now, to go on, the court says it is quite clear that Phillips is one of the small operators here, being sued for royalties, could not collect any damages under the Sherman Act for any injury which it suffered from the action of the Secretary of Labor. Now, how did the Secretary of Labor get into this? Well, the Secretary of Labor set the minimum wage for mines that sell coal to the government. And as part of the agreement, the union and the miners collectively lobbied the Secretary of Labor to increase that minimum wage, again, to the detriment of the small operators. They also lobbied the Tennessee Valley Authority to change the way in which it purchased coal for its needs. We'll get to that perhaps in a moment. So the court continued, the conduct of the union and the operators did not violate the Sherman Act. The action taken to set a minimum wage for government purchases of coal was the act of a public official who is not claimed to be a co-conspirator, and the jury should have been instructed, as the UMW, the mine workers union had requested, to exclude any damages which Phillips may have suffered as a result of the Secretary's determinations under the Walsh-Wheeler Act. So again, actions taken by the executive at the instance of one group of rivals to the detriment of the other group of rivals was beyond the reach of the Sherman Act, and that was true regardless of their intent to monopolize or do things that one might think would ordinarily violate the Sherman Act if the government were not involved. The third case in this sequence is California Motor Transport versus Trucking Unlimited. And there, the Supreme Court noted that it had said in Noerr, with really unusual, or maybe we just should say excellent foresight, that if a political campaign, such as we saw in the Noerr Railroads versus Trucking case, if a political campaign, quote, is a mere sham, this is quoting Noerr, is a mere sham to cover what is actually nothing more than an attempt to interfere directly with the business relationships of a competitor, the application of the Sherman Act would be justified. Close quote. So that was Noerr anticipating the possibility that the petitioning of the government, if you will, would be, in fact, something that was subject to the Sherman Act if it was a mere sham, whatever that turns out to mean. Well, this case arose at a time when truckers had to get permission, a certificate of authority, from the Interstate Commerce Commission if they were operating across state lines, or, as in this case, from the California Public Utilities Commission if they were operating within California, for each type of commodity that they would carry from each origin to each destination. So a typical certificate of authority might say from the Interstate Commerce Commission that such and such carrier may carry retail pharmaceuticals from city A to city B. And that truck would have to come back empty unless it had another certificate of authority to carry something back from city B to city A or go on to city C. It was an extraordinarily inefficient regulatory scheme that was introduced in the 1930s and during the Depression, but which survived well into the 1980s. Well, this case arose because the California truckers were finding that whenever they sought any authority to operate within the state of California, carrying particularly described goods from some origin to some destination, or sought authority from the Interstate Commerce Commission to carry goods across state lines, they were inevitably faced with an intervention to deny their application filed by the interstate carriers. So the California carriers were being frustrated by this necessity to overcome the opposition of the interstate carriers wherever they turned. And they finally brought the Sherman Act case, trying to fit themselves within the sham exception that had been anticipated in the Noerr case. They alleged that these competing truckers were barring them from meaningful access to government agencies and adjudication by those agencies. So they were saying basically that the conduct in question was a sham because these petitions were meant to frustrate the carriers' efforts by sheer obstructionism, by writing up their costs and causing them to overcome opposition to everything they did, in bad faith that there was not a basis for this, because not because there was some deception or bad faith of the sort alleged in the previous two cases in Noerr and Pennington, but because the objective was not to win the cases, but to overwhelm the other side. So we find the phrase in the court decision, the right to petition is one of the freedoms. Now we're getting to the First Amendment for the first time in this series of cases. The right of petition is one of the freedoms protected by the Bill of Rights, and we cannot, of course, lightly impute to Congress an intent to invade those freedoms. So again, we're construing the Sherman Act, not the First Amendment, and saying here that the same philosophy governs the approach of citizens or groups of them to administrative agencies, which are both creatures of the legislature and arms of the executive, and to courts, the third branch of government. Certainly, the right to petition extends to all departments of government. The right of access to the courts is indeed one aspect of the right to petition. But what was happening here was the court recalled, so said that in Noerr it anticipated the sham possibility. And it says of the present allegations, the allegations are not that the conspirators sought to influence public officials, but that they sought to bar their competitors from meaningful access to adjudicatory tribunals, and so to usurp that decision-making process. It is alleged that the petitioners instituted proceedings and actions with or without probable cause and regardless of the merits of those cases. So these are the key phrases that will come down through the remaining years as people sort out what is and is not a sham. The effort was to usurp the decision-making process, not to prevail in that process. Now, in this instance, the trial court had not gone into the particulars. They had dismissed the case. And so the Supreme Court had it remanded to the district court to determine whether these allegations that the truckers made against the one group of truckers against the other were substantiated, whether they were combining not to influence the decisions of the Interstate Commerce Commission and the California Public Utility Commission, but to, quote, harass and deter their competitors from having free and unlimited access to the agencies. Very important distinction as we go forward with this. The sham exception came back to the Supreme Court again in the professional real estate investors case against Columbia Pictures Industries. This was a situation in which PRE would own motels and hotels, and they would rent movies to guests. And of course, they had the equipment in each room for playing the movies. And at this point, it wasn't entirely clear whether this would be a violation of the copyright. But the movie studios, whose pictures were being shown, led by Columbia, sued for copyright infringement. And then the hotels counterclaimed that the studio's copyright suit was sham litigation, again in violation of the Antitrust laws. The court held that the litigation is not any litigation is not a sham unless it meets these two criteria: that it's objectively baseless, so that any reasonable litigant could not expect to succeed on the merits, and it conceals an attempt to interfere directly with a competitor's business relationships. The second criterion, of course, is borrowed directly from Noerr's statement of the sham exception. But now the Supreme Court has added this objective aspect to the analysis asking, is it objectively basis? In other words, would a reasonable person in the position of the litigant think it had a chance of winning on the merits? And in this particular instance, the hotels had not established the first point, objectively baseless litigation, because the studios had probable cause to sue and could realistically expect success on the merits. Not that they were bound to succeed, but it was reasonable to think that they might succeed, and reasonable to pursue this litigation in the good faith expectation and hope of prevailing. So I refer to the opinion and quote something to you here. To be a sham, litigation must meet this two-part definition. We've got that. A court should focus on whether the baseless suit conceals, this is the second part, an attempt to interfere directly with a competitor's business relationship, quoting Noerr. Because the real estate investors, failed to establish the objective prong of Noerr's sham exception, summary judgment was properly granted to the motion picture companies. A finding that an antitrust defendant claiming Noerr immunity had probable cause to sue compels the conclusion that a reasonable litigant in the defendant's position would realistically expect success on the merits of the challenged lawsuits. But then, more interesting perhaps, Columbia might have won, quoting again, Columbia might have won its copyright suit in two other circuits where the matter had been resolved. And since Columbia would have been entitled to press a novel claim in this circuit, originated, even in the absence of supporting authority, if a similarly situated reasonable litigant could have perceived some likelihood of success. So the key phrase here is probably some likelihood of success. It's not bad faith litigation if there's some likelihood of success. Now, that, of course, is something that can be litigated on the facts of any given case, indicating whether the plaintiff really had a sound basis for thinking it might succeed. What did counsel advise? And what sort of odds were they told? What expense they were going to incur? Would a reasonable litigant have undertaken that litigation or course of litigation if it really was hoping to win rather than just frustrate the competition from its defendant? Our next case is the Federal Trade Commission's case against Shire ViroPharma Incorporated. Now, this was a case in which the FTC was seeking an injunction under 13B of the Federal Trade Commission Act. Shire had filed 46 so-called citizen petitions before the Food and Drug Administration, intervening to disrupt the efforts of generic firms to introduce generic version of a drug that Shire had on the market. Of course, the introduction of the generic would cause Shire to reduce the price of its branded drug by probably 85 or 90%. So it had a great big stake in trying to prevent entry into the market of a generic competitor. It filed 46 so-called citizen petitions, and the case never got resolved on the merits because the Federal Trade Commission brought the case 5 years after Shire had filed the last of those petitions. Now, it was within the Federal Trade Commission's statute of limitations, which I think was 6. But no matter, 13B requires allows the FTC to seek an injunction when the party it's suing is violating or is about to violate the law. And of course, here the conduct had ceased 5 years earlier, so the FTC could not say that it was about to violate the law, and there was no indication that it was imminently going to revert and resume the same pattern of conduct. So the case was not resolved on the merits, but it does represent the first instance, I believe, of the FTC now taking up the cudgel against the sham exception. Our last case in this sequence is the Federal Trade Commission's case against AbbVie Pharmaceutical Company, which is still pending in the Third Circuit on appeal. It was argued a few months ago. Here, the Federal Trade Commission brought its case under Section 5, not Section 13 seeking an injunction, but Section 5 against anti-competitive practices, alleging that AbbVie had tried to maintain its monopoly on a drug through sham patent infringement lawsuits against generic competitors. And the district court now, with the benefit of the Supreme Court's decisions, said, well, AbbVie's lawsuits against competitors were objectively baseless. And second, the FTC had to prove that AbbVie had actual knowledge the patent infringement was baseless. So we're going to look behind the case. We know it was baseless and ask, well, was it brought even though the plaintiff knew it was baseless or was advised by counsel that it was such a long shot as to be effective baseless? Well, in a particular case here, the Federal Trade Commission prevailed. It showed that AbbVie had knowledge that the suits were baseless and acted in bad faith to bring them anyway. And the FTC brought out, and the court relied upon information coming from counsel about the improbability of winning this case. The inside counsel were experts in the field in patent litigation and had every reason to believe that this was not going to be winning. These patent suits were not going to be successful or brought. So the very essence, finally, of a sham case after professional real estate investors explains the two different things that have to be shown. It's not an easy showing to make. It often will require discovery of internal documents to support the second aspect of the claim, that there was actual knowledge, not just that a reasonable litigant would have known it was baseless, but the litigant did in fact understand that it was baseless. So to sum up, the Noerr-Pennington Doctrine tells us that concerted action by competitors to get government on its side in order to suppress its rivals, whether it's the legislature, the executive, administrative agencies, or courts, is immunized from liability under the Sherman Act. The Sherman Act simply doesn't reach collective efforts to influence the government, whereas the real liability will lie under the Sherman Act for sham efforts to influence the government, those that are baseless and knowingly pursued anyway. Well, that partly explains why we have so much rent seeking for anti-competitive purposes, but it seems that the court, I think anyway, really had no choice but to accept that petitioning the government, no matter how anti-competitive the purpose, is a constitutional right, and they never actually said that as the grounds for deciding any of these cases, that the Sherman Act could not be interpreted as invading that right. Thank you. See you next time.